Section A of the UN Protection of Human Rights, we are looking very much at the framework which the UN has established in the last 60 plus years. Initially, we begin by looking at the Universal Declaration of Human Rights, but the Universal Declaration of Human Rights, which was one of the first resolutions adopted by the General Assembly on the 10th of December 1948, hence why the 10th of December is known as International Human Rights Day, was not a binding document, and it wasn't intended to be. In the words of Eleanor Roosevelt, who commissioned the committee that developed the Human Rights Declaration, it was designed as a blueprint, as a guiding light for states as well as for the organization. It sets out in considerable detail the rights and freedoms which it is believed should be enjoyed by all. But it didn't set out hard obligations to states. It just called upon states. In fact, Articles 55 and 56 of the UN Declaration on Human Rights are very good examples of soft law. They are aspirational, and they call upon states to work with the organization to realize the human rights and fundamental freedoms of individuals. However, in order for these human rights to be more than just aspirational, they had to have detail, they had to have flesh added to the bones. And the flesh came by way of the UN Covenants on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. Now, both of these covenants were drawn up in 1966 and were open for signature. But it was some 10 years before either of them came into force. The Civil and Political Covenant is considered in Section A, as is the Covenant on Economic, Social and Cultural Rights. Not in great detail in this context, that comes in later sections, but rather as how, for example, the mechanism for monitoring compliance with the respective covenants has become a blueprint, particularly that as prescribed in the Civil and Political Covenant. By a blueprint, I mean that what has become standard is that, and what has become universally adopted in any subsequent treaties drawn up under the auspices of the UN, is that there is a reporting mechanism, a reporting system, whereby all states that sign up for a particular convention have an obligation then to make a report on what steps they have taken to realize the rights that are contained within the treaty in question. In addition, the Civil and Political Covenant set up a committee, and again, committees have become standard. The parent treaty will set up a committee designed of individuals who are chosen for their independence, and these individuals will sit not as a full-time body, but possibly 3 times a year, and will consider on a rolling basis the reports that are submitted by states. However, also, and again we deal with that in more detail, there is the individual complaint procedure, which was set up initially in the optional protocol to the UN Covenant on Civil and Political Rights. And that is novel in that it provides the opportunity for individuals who believe that their right has been violated to bring a case against their own state. And it's novel because, of course, it exposes that state to external review. But it's not maybe quite as novel as it seems, in the sense that, of course, the state has had to consent to that practice being adopted. So an individual has a limited right of redress and the redress is dependent upon the state having given consent. These issues are all dealt with in what possibly we could say in generic form in Section A. We also look at other mechanisms that have been adopted to give flesh to the particular covenants. For example, the process or the habit of giving general comments. These general comments are the product of the committee. For example, the UN Committee on Human Rights, or the Human Rights Committee, has done a number of comments relating from actual procedure, what's the nature of the obligation on a state, and has also given instruction as to the way in which a particular article should be interpreted. In addition, in Section 8, we also look at the UN Charter-based mechanisms established, the protection mechanisms established from the Charter, such as the UN Commission on Human Rights and the role that it played until it was replaced by the Human Rights Council, and the role that the Human Rights Council has now assumed, and its novel universal periodic review procedure, whereby it has sought to give a human rights review of all 193 states that are members of the UN within a 4-year period. So we also look at the workings of the Human Rights Council and the various what we call special procedures that can be adopted and the thematic approaches to certain human rights and the way in which the Human Rights Council will possibly engage with a member state where there has been an alleged violation of a human right. So Section A is very much an overview of the working of the UN, the system that we're provided for by the Charter, and that provides a good foundation then to look at greater detail, as we will in the subsequent sections, on the treaties which seek to protect human rights.